In today's lecture, we'll talk about community monitoring of natural resource systems and environment where law meets science. And we have the pleasure to listen to the experiences of two renowned practitioners of civic environmental monitoring, Berti Suman and Dimitris Arghiriou. And Anna is a researcher, lawyer, and activist on civic environmental monitoring. And she founded the Sensing for Justice project on civic evidence for environmental law enforcement. And she's a research fellow in sustainable innovation law at Lewis University in Rome. She's a qualified barrister following climate and environmental law cases at Systasis, which is the Center for Prevention and Management of Environmental Conflicts in Milan. Dimitris Arghiriou is the founder of Forest and Peoples Organization, an evidence-based advocacy company that aims to use data, technology, and maps to highlight issues faced by indigenous population, mostly regarding forest conservation and environmental protection. And my name, as I said, is Nerea Turreira, and I'm an assistant professor at the University of Copenhagen. I do research focusing on the inclusion of local ecological knowledge in participatory environmental monitoring and citizen science. And I will chair today's lecture and manage the Q&A session. And we really value your participation in this lecture. We would like to hear your opinion and experience in this subject. And therefore, we will share a couple of questions for you to take part during the webinar. And we hope to have a fruitful discussion in the Q&A session. So here, as a brief introduction to today's lecture, today we'll talk about 3 cases using citizen science data for advocacy and court that will bring us to Southeast Asia, the US, and Europe. And the aim of the lecture is to talk about our experiences in these parts of the world using monitoring data of different systems, forest, water, and air, and discuss our lessons learned to bring ideas for participatory environmental monitoring during and afterwards war in Ukraine. And now, without further ado, I leave the floor to Dimitris Arghiriou. Thanks.
Well, thank you, Nerea. I would also like to welcome everybody to this webinar and thank GROMADA and the University of Copenhagen for the chance to present our insights on how forest monitoring coupled with citizen science can generate quality data that can be used as evidence in a court. I want to highlight that our case is about using forest monitoring data for conservation advocacy and see what we can learn from this case and apply it in the context of Ukraine. I'm in no way going to try to compare our case with what Ukraine is passing now. And our thoughts is with you, and we support your causes. Before we start, let me remind you that a month ago, we explained in detail the process of developing a forest monitoring citizen science application involving local communities. And today, I will briefly recap a few points about this presentation, but please do not hesitate to check the online lecture in YouTube and that Nerea has posted in the chat. And now straight to our case. First of all, let me take you to a small e-trip. So we can see here Europe and Southeast Asia, and this small highlight country in the right is Cambodia. Let me bring it a little bit closer to you. So this is Southeast Asian Cambodia, and this is Cambodia, which is a country with high biodiversity. It has around 50 protected areas of different designations and counting around 7.3 million hectares of state protected land. However, from 2001 to 2023, Cambodia has lost almost 3 million hectares of tree cover, equivalent of 32% decrease in tree cover. And the actual problem is these guys here that are named economic land concessions. These are companies that are usually highly connected with the government, and they lease the land for 50, 100 years in order to carry out their economic activities. They might be producing rubber, sugar, but also timber. The government released a moratorium on new ELC permits back in 2020, but they didn't manage to keep their promise for a long time. They have returned to award mining licenses even inside the protected areas, as you can see from the purple schemes. So moving on, our area of interest is this blue highlighted area in the central plains of Cambodia. Its name is the Prey Lang Forest, and Prey Lang in the local language means our forest. It's about around 500,000 hectares and is the largest lowland evergreen forest in the Indo-Chinese peninsula. And this forest holds a high ecological, economic, cultural, and spiritual value for the indigenous Kui and Khmer population. Let me bring it a bit closer. As you can see in the close-up, it is surrounded by economic land concession, but also contains a lot of mining concessions that are extracting gold, copper, and other precious and not precious metals. These concessions are not there accidentally. They have a certain strategy that have been following year after year. So their target is the valuable tree species inside the protected area that after being laundered through their grounds are then exported to third countries like China, Singapore, Vietnam, and finally they find their way to Europe. As a result, Cambodia has one of the highest deforestation rates in the world, and massive land grabs and the related illegal logging are destroying the forest. So according to data from Global Forest Watch from 2001 to 2023, Prey Lang lost more than 85,000 hectares of tree cover. It's equivalent to a more than 20% decrease in tree cover. The Prey Lang community now, or PLCN as we call them, emerged in 2001 as a response to the rampant illegal logging and land grabbing, threatening their ancestral lands around Prey Lang. Initially, local communities bonded together to protect their access to natural resources. Over time, PLCN evolved into a well-organized coalition with a clear mission, safeguarding Prey Lang in collaboration with various stakeholders. So central to PLCN's activities are regular forest patrols conducted to monitor forest resources, document illegal activities, and track climate change effects. One of the main subsistence activities for the communities in and around Prey Lang is tapping resin trees and selling the resin in nearby markets. The problem is that there are no hard land titles in Cambodia, and the ownership of these trees is passing from generation to generation. So resin trees are also valuable trees that are targeted for their timber from the adjacent companies and their loggers. Till 2015, the PLCN members used notebooks to document illegal logging activities and shared with local authorities, emphasizing the grassroots origin and the collaborative nature of PLCN's efforts. So on 2015, the project Prey Lang HR Forest 2 was formed between local and international NGOs and universities, and having in the center the local communities, in order to help them engage in peaceful dialogue for forest protection with the help of ICT. I will not go into a lot of details as we touched this on our previous GROMADA webinar, but the main outcome was the co-creation together with PLCN of a forest monitoring application to collect citizen science data about the status of the forest and use them to advocate for their protection. And this is the Prey Lang app, a citizen science forest monitoring app. It's a smartphone application that was based on the Sapeli platform, and it was chosen because it was specifically developed for use by people with limited experience with technology. The application was modified by a local IT company based on the community's input and feedback. So the Prey Lang app is compiled from 3 distinct types of information. First of all, reference data like time, date, and GPS coordinates that are automatically attached to the observation. A primary documentation, which is a photo or an optional audio or an optional note for every new data point. Finally, a thematic tag, or better, a category is being attached to the observation in order to give more information to the entry. So the 3 main categories that the communities were interested to document were valuable resources of their forests, such as non-timber forest products and trees, illegal activities such as logging, poaching, and mining, and reporting interactions with authorities. Each main category has a limited number of subcategories that add extra information to the observation. At a later stage, 2 new categories were added to broaden the scope of the monitoring to reporting of climate-related events and reporting of threats or instances of violence to enhance the feeling of security to the community. As you can see on the photos, the categories are illustrated by drawings to allow participants with low literacy to navigate the app more easily. And these, as we say, were the monitoring wishes of our communities. As some of you might know, in the GROMADA Summer School in Hamburg, we aim to carry out a workshop on constructing an environmental monitoring app with a focus to Ukraine. So I would like to invite you to think, what could be the aim of the environmental monitoring project, and what kind of data would be feasible and interesting to collect for a project in Ukraine? So think about it, and we can discuss that in the Q&A session after our presentation. But what does the community report? As you can see, there has been more than 50,000 entries received since the conception of the project, and almost half of them are validated. Out of this, reporting valuable resources is the favorite, and to tell you the truth, the most beautiful category of our communities, with more than 60% of entries. Second and most important is the category of illegal activities, and smaller percentages for climate-related events and other entries like workshops and training. Although it might seem a very small amount, this 1% of reporting interactions include over 60 threats to community members. Threats to beat them, kill them, burn their properties, harassing their families, the work that the communities are doing. You understand that in a network with a few core members, this amount of threats are not negligible. Cambodia is not a safe environment for environmental advocates. Given the situation that Ukraine is in now, I would like to take the opportunity and invite you to think, how far would you go reporting environmental crimes when the safety of you or of your family is at stake? There will be a poll launched regarding this question at the end of the presentation. So moving on to the results of the monitoring again, I would like to break down the logging category that contains 99% of the entries of the activities. In this very important category, we can find around 50% of the entries regard single cut trees or stumps, as we call them. And these are usually trees of high value in the market, but also are the resin trees and the sacred trees of the communities. 23% of the entries regard transportation of illegally felled timber, and 20% of wood that is left on site in order to be gathered from a vehicle at a later point. The 17% of the cleared areas might seem low, but this regards greater areas of hectare or more that are cleared inside the protected area. Finally, the monitoring of the community's valuable resources includes around 75% of trees, and a big chunk of them regard resin trees. 16% of non-timber forest products like mushrooms and plants that they encounter in their day-to-day walks in the forest, but also 66% of animals and 2% of sacred sites. And I know graphs are nice tourism data, but how do the actual entries look? And what kind of data actually we can draw that could hold the perpetrators accountable? So first and foremost, we have the location of thousands of cut trees that are targeted for luxury timber supplemented with a proof, like photo, nodi, or note. Secondly, we have larger cleared areas and their locations, and sometimes the names of the perpetrators. We have proof of transportation of illegally cut timber, as well as the hotspots that the transporters tend to pass. We also have proof of economic land concession operating inside the protected area. And finally, we have the locations of the resin trees of the communities. As I explained earlier, the main output of our data is advocacy for environmental protection. So how do we visualize our data? First of all, we have constructed the Integrated Forest Observatory System, or IFOROS as we like to call it, an online platform that includes all the forest monitoring data that the communities allow us to present. Logging activities, climate-related events and interactions, but not the location of their valuable resources, their resin trees. This is the English version and has a very basic design. And here you can see the Khmer version that has a more modern design, but it's exactly the same data. The platform couples the forest monitoring data from the ground with satellite monitoring datasets and other publicly available datasets in order to provide more context and present proof of the environmental degradation in the activities. We are also releasing forest updates quarterly, summing up the findings of our communities, showcasing the most striking examples of deforestation, coupled with satellite imagery and the beauty of their lands. Finally, we are releasing a yearly report that looks back of what has happened during the past year and gives more context on the policies and environmental activities that regard the protected areas in Cambodia and are printed and distributed locally, but also online. Feel free to explore the data and all the resources through the links posted in the chat. On the policy level, we have also answered the call of the United Nations Refugee Agency and submitted a report on the militarization of indigenous land with data from our monitoring. And the special rapporteur on human rights has also received a list with descriptions of the recorded cases of threat and violence faced from our communities that I talked about earlier. And this advocacy strategy has led Preyland Community Network to an extended international recognition. PLCN has received 5 international awards from recognized authorities, including the Equator Initiative Prize from IUCN. As a result, the media attention has skyrocketed. The issue of Preyland is visible weekly in the national media. Nationally, Preyland Community Network has grown to be a recognized stakeholder. It was initially invited in a public consultation about the new environmental law in Cambodia. And finally, Preyland was declared a wildlife sanctuary in September 2016, after long petitions of PLCN. Although on the ground, little things changed. Finally, our robust approach with trainings, capacity building workshops, and innovative use of technology has attracted 2-3 more communities to apply the same approach. But this didn't come alone. After all, we shouldn't forget that Cambodia is an authoritarian regime where the government has banned the biggest opposition party and critical media. Human rights are deteriorating and the biggest tycoons have great connections with the government, and this doesn't leave the judicial system unaffected. Communities like PLCN that are critical to the government are the ones to pay the toll. PLCN has been officially barred from entering Preyland Wildlife Sanctuary since February 2020, thereby greatly hindering the monitoring of their legal logging activities. Communities are also prevented from carrying out their annual ceremonies that happen inside the protected area. Public and also private threats are not absent. Pilsen has been threatened with arrest if the satellite monitoring continues during the COVID years, while outspoken activists have been locally targeted, harassed, and arrested. To sum up, these are the lessons that we learned and might be useful in an environmental monitoring project in Ukraine or elsewhere. First of all, the legal conservation status is not enough to protect the forest. We need local forest patrollers. We need communities engaged in such a project. Communities that are in the forefront of this kind of projects and require our support whenever this is needed. So for the generation of this quality data, we need this feeling of community ownership in such a project that motivates the communities to collect and actively participate in such a project. Finally, supporting from international community, it's a grand necessity in terms of campaigning, sanctioning corrupted officials, condemning human rights violation, or even just media attention and acknowledging the constant fight of the indigenous communities. As our experience in Cambodia dictates, access to judicial system is not a prerequisite and the fair trial is not given. This is all from my side. Thank you for your attention. Please don't hesitate to follow our links in the chat and support our communities and environmental defenders in Cambodia. Thank you so much, and back to you, Nerea.
Thank you very much, Dimitri, for a very informative talk. And well, we have seen that community monitoring in conflict areas can be a dangerous activity. And we wanted to get a sense of, get a small reflection from each of you, from the audience, and like see if you would be willing to report environmental crimes, even if the safety of you or your family was at stake when doing so. So I'm going to launch a poll when I find it. Yep. So, all right. So I believe that you can see the poll now, and you're very welcome to answer. Well, this is just for us. It's to activate the audience and to get a small reflection on what we just heard of how community monitoring data can be used for environmental protection, even though sometimes it's risky and a dangerous activity. All right, I'm gonna give it a few more seconds for people to reply. All right. So I'm ending the poll now, and I hope to, yes, be able to share the results. So we could see that, I mean, some people don't want to answer, and that's fair enough, of course. Most people answered no, but many answered yes. So I think it is, well, it is quite something. No, not everyone is willing to risk their life for the environment. However, there are people who really believe that it is very important to do environmental monitoring, sometimes of environmental crimes, environmental pollution. So this was insightful, and if you are willing to talk more about this, we can do so during the Q&A. And now I'm gonna leave the floor to Anna. She's gonna talk now about exactly bringing civic monitoring data to court. Anna, the floor is yours.
Thank you, Nerea, and thank you all, especially Dimitri, because I think what preceded me offers a great follow-up exactly to think about where can this data end up if we really want to have it for change, so really to change something. So I will talk about how civic data, when it becomes evidence, may enter court to demonstrate environmental wrongdoing, with the aim to debate how these lessons that I gathered over a research project of 2 years and a half could be actually transferred one day also, and even now, to Ukraine. I was already introduced. Let's say that here I talk from my environmental lawyer perspective, but also from a researcher perspective, but also as well from a citizen perspective, because what I will share with you is really something that all of us can really do with all the resources that we have. So we don't need to be a particular expert of a topic or have specific tools, but we need some common ground resources that I will also share with you. So first of all, I would like to introduce you the Sensing for Justice project, Sensius in short, which is somehow a friend of the GROMADA project, because when the idea of the GROMADA project came to be, we exactly wanted citizen science to mobilize in Ukraine, not only, which is important for educational purposes, but also to foster justice in the recovery process. And this starts already when the war is ongoing, because indeed we need to gather evidence. We need to have information, and through information, we would have the agency to then claim justice in courts. So the Sensing for Justice project was funded by the European Commission, basically in particular by Nerea, the Marie Curie grant, and also previously by the Dutch Research Council, and still is a sister project of the GROMADA project. And it posits three main pillars. First of all, the project wonders how civic monitoring can offer data that can be admissible in court to demonstrate environmental harm. Second, as the possibility to bring evidence comes with risks, as Dimitris exactly pointed to, we need to have a legal ground to perform this. And this is why throughout the project, we propose the right to contribute environmental information. And I was particularly pleased that the UN rapporteur on toxic and human rights came to us with interest in this concept, because more and more we understand that we cannot think to environmental information only in a passive way, so only in the sense of accessing governmental or company information out there, but there is a quantity of environmental information that we are producing actively or passively as ordinary people, as users. And all this information should be considered, provided that is of a certain quality and accuracy, should be considered by those authorities that are in charge of handling environmental issues. So the right to contribute environmental information is key also to shelter environmental defenders against potential consequences of their act of monitoring. And lastly, as you may be aware, the judiciary is often a lengthy and costly process, and sometimes already having the evidence can push companies or governments to find a solution outside the court through what we call as alternative dispute resolution or mediation. Okay, mediation, let's say it's a bit broader, as it may also be a social form of mediation when an environmental conflict is resolved not in a court setting. So bear in mind these three pillars as we now move to a more concrete application. So first of all, we discovered that there was really little written out there on the use of civic evidence in court. And this is also something that we will ask you in a poll. So bear in mind this question and start thinking, like, are you aware of any case where citizen science was mobilized to demonstrate harm in courts? Or all the manifestation thereof. So it may be civic monitoring, collective intelligence, virtual, like volunteer geographic information. So think to it as a complex and sort of umbrella term that encompass multiple practices. So what we were doing at the start of the project was really to scan the landscape and identify cases, especially in Europe, that had some signals of introduction of civic evidence in court. And to do so, we had to learn from somewhere, and we found that in the US, this practice is way more solid. And even in Latin America, there were way more evidence compared to Europe, which was really insightful for us because we understood that in Europe, citizen science doesn't dare to enter courts, whereas in the US and Latin America, this has been more common. After the scanning the horizon, we selected interesting cases through purposive sampling. We also complemented our selection, let's say, with strategic interviews with lawyers, community leaders, civil society organizations, judges, to really understand what was the right combination of cases. And then, especially where we could, we performed in-depth ethnography. And it doesn't mean that we went to all the places, because we preferred to stay low in terms of emissions, and there was the pandemic in between. So we went physically, for example, to south of Italy, in Basilicata, famous for the oil extraction impacts, but we went virtually to several other places through a so-called virtual ethnography, which means when we can follow an activist, a lawyer, a community leader through, for example, their smartphone, their narration. And this is particularly viable, in my view, in work context, because it's not possible for all the researchers to go there physically, but still we can help a lot through a sort of remote connection, understanding which type of evidence you are collecting, which type of evidence is missing, and how we can pair activists with researchers and lawyers. So moving to the power of these cases, what these cases have in common, which is probably also what Dimitri's presentation showed us, is that they start from the ground. They have the potential to mobilize civil society actors because this is a pressing issue. I often talk about the paradigm of the civic sentinel, because a civic sentinel and a crowd of sentinels, not in the military understanding of sentinel, but in a social understanding, are people that mobilize because they are deeply concerning and caring about an environmental issue. And they strategically deploy their resources, their energy, for example, with lawyers, with civil society organizations, to find a way to tackle it. And we were interested in cases where this response took the form of going to court. Now, I would like you to consider that the number of cases that come to the court stage is extremely limited, essentially because it's indeed very costly and very time-consuming. So most of the cases do not go to the court stage, which is also good because going to the court is really the last resort. But it sets a precedent. So it's really remarkable. So when a case decides to go to the court, then he plays all its credentials. If he wins, then it may be game changer. We saw, for example, for climate change with numerous pronunciations like the Urgenda case, that was game changer. We call it a precedent. And the Formosa case in Texas was exactly a precedent. I cannot go now in all details of the case, but I'm happy to return to it in the Q&A, or also you will find some resources in the chat related to the case that were taught also for civil society organizations, so they should be rather accessible. In the Formosa cases, a group of fisherwomen and fishermen managed to demonstrate a massive violation of the US Clean Water Act and the permit that allowed a petrochemical company to operate in the Lavaca Bay in Texas. And they demonstrated this based on civic collected evidence, which looks exactly like you see in the picture. Basically, bags filled with what they call nardoles, which are little plastic pellets and powders that are a clear violation of this legal framework, the US Clean Water Act and the permit, because, and this is quite important, the permit says that plastic releasing water shouldn't be visible with bare eye. So this is a standard that is so easy to demonstrate with citizen science, which is also what makes the case quite unique and not always replicable in other contexts, because indeed many citizen science initiatives, as the one that I will show you later, are not so evident, like they monitor radiation or air quality. And so this is an important element to consider. If you can demonstrate the violation without any sensor, any particular measurements, but really gathering in a systematic way the proof of the wrongdoings, this is the way to go. So really, it's the easiest way that a court may find your data, your evidence admissible. Interestingly, the case was so successful that apart from the bilionary judgment that was then awarded to the community and paid in compensation, the community now has the responsibility, also the right, to oversee the monitoring by the petrochemical company of its release in water. So they also have a role in the enforcement of the consent decree, is called the judgment. In addition, they are also, and this is also interestingly, driving reform in the regulation. So there's a new regulation in the US mandating zero plastic discharge production. So any plastic petrochemical company should produce without any release of plastic in the water. So the standard even improved after this clearly impressive case. Interestingly, the petrochemical company is a Taiwanese multinational known for bad habits in all over the world. And the Formosa plaintiffs, so the actors, the civil society, are creating networks with civil society affected by Formosa all over the world, which is the power of the network. So the case, as I was saying, it's really impressive. In the end, Diane Wilson last year got the Goldman Prize for Environmental Protection, which is also quite stunning. But again, the evidence was quite simple, massive coverage, experts complemented the evidence. It was easy to demonstrate that the fishers were affected because their livelihoods depended on this water. And Diane Wilson was clearly a dedicated champion with ability to also move advocacy, media, and so on. Now, let me move to a case where, let's say, the type of measurement is less easy. And this is the Belgian case, in particular, Greenpeace versus the Flemish region, so against the Flemish region. And it was a case basically aimed at European Court of Justice, the Court of Justice of the European Union, intended to demonstrate the entitlement of affected citizens in the Flemish region to a right to clean air. So do these people have a right to clean air? Unfortunately, the court said no. So the right to clean air was not recognized. I won't go in depth into this pronunciation, but I have an article for you from Delphine Mison that really goes into depth of the case if you're interested. But what is interesting for us in this specific case is that citizen science data deriving from a famous air quality civic monitoring initiative called Curious Nosen, like curious noses, was presented to the court together with official data to demonstrate violation of Article 6 of the Ambient Air Quality Directive. And interestingly, the question to the court was, is the Flemish government obliged to report this data, the official data, but also the citizen science data to the EU to demonstrate compliance or incompliance with the EU air quality directive? And the court said, even if it didn't recognize the right to clean air, it actually said that reporting this citizen science data if it serves to demonstrate, for example, incompliance with EU limitation for air quality, and it can serve as indicative measurements, which is really a kind of a provision in the law, then it should be reported. And this is very interesting for us because it means that citizen science data shouldn't be considered as the official in terms of quality and accuracy, but can be indicative of violation, basically triggers to, for example, a prosecutor's inquiring into a deeper violation. So, of course, in the other case, it was evident, massive win, but still we feel that this case was interesting for kind of demonstrating that citizen science data can provide an indicative measure that is complementary to that every government, every state has to pass to the European Commission. So we call a partial win. Now, let me conclude to a word saying that it's important that courts in their gatekeeping roles, when they look at these cases and decide which cases to adjudicate, but also legal professionals that are helping communities to go to the court. All these professionals should be aware that civil society actors risk a lot in producing this evidence. And this applies also to us as researchers, because we can be at risk or be the safe ones supporting, for example, the community actors. But in both cases, it's important to recognize the accuracy, the validity of this data, but also to spot, for example, issues with silencing of defenders, criminalization, or also when we find that a certain type of evidence may be considered fabricated. So we are really, as professionals, kind of the steward that citizen science data enters court for good. And this is all for me. I really look forward to discussing these or further points. You can find numerous resources here in the list, but also please do engage in some follow-up events. In particular, we will have an expert legal workshop. Nerea will tell more about this, especially if you're interested in the legal dimension of the project. Do check the also future webinar series, especially dedicated to the Aarhus Convention and also to civic monitoring for environmental law enforcement. So more to come. Thank you for your attention.
Thank you, Anna. That was really informative, very well explained. And I'm not a legal expert in any case, and I could really follow. It was really well explained. I will now launch the poll that you suggested to ask the audience if they know any case of use of citizen science data in court. apart from those that Anna just said, of course. But let's leave a few minutes for that. All right, maybe 10 more seconds for people to think about this and respond. And I hope that you can also check the links that have been posted in the chat with all the cases that both Dimitris and Anna have shared. Okay. I will now close the poll. So we can see that most people are not aware of citizen science data in court. However, some people do, and you're very welcome to share your experiences during the Q&A session. And I think that it also talks that maybe this is not as common, and maybe we need more of these kind of webinars and talks to bring up this kind of cases. As you, Anna, mentioned, the more precedents there are, the easier it will be. I will now stop sharing the poll. And I just wanted to conclude, make a small summary of the presentation. I'm going to share my screen. Okay, and now I want to see my notes. Yes. Yeah, so I think that it has been very nice presentation from both of you, from Dimitris and Anna. From Dimitris, we could see how we can come up with a participatory data collection method, how to involve community, how important it is to collect this data, and especially in conflict zones, and how important it is also this enabling environment. So we saw from the Cambodian case that it's very important that civic and local monitoring takes place in order to ensure environmental protection when the legal enforcement is not working. However, he also reminded us that it's very important to support these civic and local organizations from the international and the national communities, for them to be able to reach out to a larger audience, to reach out to different organizations, and bring up their advocacy tools. And from Anna, we could actually see how this data can make it to court and also environmental mediations. And as I said, the amount of the more cases that there are that set up precedents, the easier that it will be to lead the way. And we could also see that not everyone, that is not always possible, but we can always learn from this kind of cases also from the Belgian. There were very good learning outcomes from there too. And I got some summary points from Anna that she mentioned that the nature of the civic evidence may have a strong impact in the success or the failure in court, and also that the quantity and the time coverage of the data, as well as its accuracy and reliability, are preconditions for admissibility in court. The complementarity of the evidence is also key to success. And one of the barriers is to demonstrate the plaintiff's standing and injury. And a dedicated champion, media coverage, and advocacy are essential. And the court may not adjudicate the case, and yet mandate the states or companies to consider citizen science data. So even though the case is not won, the recognition by a court of the value of citizen science data is also a game changer. So I will now take Okay, I see that there are questions, but maybe let me finish this and then I take out the Q&A. Okay. I just want to mention that there is a next lecture on citizens' assemblies and advocacy for environmental justice in Ukraine. And this is going to take place on the 28th of May at 6 p.m. In Central European Time. And the speakers will be Miroslava Savisko from Kiev School of Economics, and Leslie Ann Duvich-Paoli from King's College London. And it's going to be moderated by Stefania Ikomonou, sorry, from Go to Learn. And I'm going to paste now the link in the chat in case you want to register. And as Anna mentioned, there's going to be a workshop on legal experts, lawyers, and community cooperation for environmental citizen science and peace building in Ukraine. And this is going to be led by Anna. It's going to be a 3-hour interactive workshop. It's free of charge and it's super interesting. So please sign up in the link that I will post now in the chat. Yeah, so I really want to thank everyone for your attention and make sure to check our project website, the LinkedIn profile and YouTube channel if you want to stay tuned about all these lectures that are covering a wide range of topics on environmental monitoring and law. And here there are the email addresses from the speakers in case you want to contact them for future comments and questions. And now I'm gonna